What's going on, everybody? TRAE4JUSTICE back in the building, coming at you guys with part 2 of day 13 of the Darrell Brooks trial. So we're finally wrapping up this day where Darrell spends a majority of it in the other courtroom. Now, you would think that's like a dream come true, but with Darrell being the grimy opportunist that he is, he finds a way to make it stressful as he can, even when we should really just enjoy the peace of the process taking place without him constantly interrupting it. Yeah, none of that happens. But I do want to say I really hope you all are doing well everywhere. I hope you all are staying safe. Like, this is going to be really strange when this series is wrapped up. I'm so used to watching these videos at this point that it's going to be very strange once this is wrapped up. Oh, and also a happy Veterans Day. I realized after the fact that I didn't make a community post about this. So I just want to say in the video, thank you to all the veterans. Okay, I started to get anxious when I feel like I'm dragging out the intro a little too long. So I just want to say thank you to a few people that donated, and then we're just going to get straight into the video. So thank you so much once again to Letitia for a $5 donation. I really do appreciate it, and thank you so much for continuing to watch along and for sticking with me. And you know, a lot of these names I've seen before, so I do want to acknowledge that. Thank you so much. And to the people that have let me know, like, oh, this is the first time I've ever donated to a channel, I really couldn't begin to explain to you all how much that means to me, because I've never thought that I would have like a community like this, or to be able to like make these kinds of videos, which I love doing. Okay, sorry about that, but thank you so much to Kathy Jones for a $10 donation. I really do appreciate it, and thank you for continuing to watch along and for sticking with me as well. Thank you so much to Nightingale 007. I hope I said that right, but thank you for a $2 donation. I really do appreciate it, and thank you for continuing to watch along and for sticking with me. Thank you so much to April Smith for a $5 donation. I really do appreciate it. Thank you so much for continuing to watch along and for sticking with me as well. Thank you so much to Ty Tyler for another $5 buy me a coffee donation. I really do appreciate it. Thank you for continuing to watch along and for sticking with me. And last but not least, thank you so much to Kelly Davidson for a $5 buy me a coffee donation as well. Once again, I can't begin to explain to you all how much I appreciate it, but what I do want to say is no one has to send me a single thing. But if you would like to donate to the community of Waukesha and the victims, there are links pinned at the top of the comment section. Okay, I don't want to hold you all up. Love you all, and I hope you enjoy the video. Thank you. Okay, he's back in the courtroom with everyone else.
All right, we are back on the record. It is 1:01 p.m. State versus Brooks. Appearances are as they were before. I would note I have instructed, and Mr. Brooks is present in this courtroom. Prior to the, I understand your objections noted. If you would like to go back to the other courtroom, sir, you may, but that is a choice that you would be making. I am not requiring you. I'm not forcing you at this time.
So you're not holding me in contempt?
Sir, I am not requiring you or forcing you to go into the other courtroom. It is a new part of the day. I thought it appropriate to have you brought here.
Why?
And only if you forfeit your right by conduct will I put.
It's crazy that after 15 days, he still doesn't know what being held in contempt means. And I don't know if you noticed it, but now he's just asking, like, well, what is that? Why am I back here? I don't understand. Like, now he's just going for whatever he can, I think, just to hold up this process. I mean, that's the first time he's really, well, no, it's not the first time he's done it. Let's see if he continues with that, though. I'm thinking that that's what he's about to do right now.
Put you back in the other room.
So you're going to address subject matter jurisdiction for the record, or are you going to state it on the record?
Okay, never mind.
I'm planning to address that on the record for the reasons I've previously provided to you, not the least of which is I have addressed that by way of a written decision.
And it hasn't been proven for the record.
Your objection is noted.
Can I go back in the other courtroom? Because I'm not going to do this with you. I'm not.
Mr. Brooks, I do want to go
Yes,
over
please.
We don't have
jury instructions.
I don't understand the jury instructions.
He's made his decision.
Anything is in these proceedings, and I'm not going to participate in something that I don't understand.
You're doing the right thing, Darrell.
May I please go back into the other courtroom?
You can, based upon your choice and your request. I'll make a finding that he's forfeiting his right to be present in this
I didn't forfeit
courtroom.
anything. I asked.
I understand you've
So
asked, but
I
I
didn't
feel it's
forfeit
important to
anything.
also make a finding based upon your conduct.
Based upon what conduct? Me asking?
Are you willing to expressly waive that right on the record right now?
I'm not gonna expressively waive anything.
Are you willing to
I'm making
engage in a colloquy regarding your right to be present
I
and
do
a
not.
knowing and intelligent and voluntary waiver of that right?
I am not going to consent to anything that I don't understand, and I will not answer any questions that I don't understand. I'm merely making a request to not be present in these proceedings.
And to be in the other courtroom?
Again, as I've stated numerous times now for the record, I will not answer or comply with anything I do not understand.
You don't understand that question?
I'm not making a voluntary waiver of anything.
Are you willing to be, let me rephrase that. If I have you stay in this courtroom, are you willing to follow the rules of decorum and courtesy?
I do not understand the question you are asking.
Are you willing to not interrupt the proceedings with disruptive behavior?
I do not understand the questions that you are asking.
Sorry, this is so upsetting right now. He is asking, he's basically begging to be kicked out. I wish you would kick him out again. Like, this is honestly a layup. He doesn't want to be here. So yeah.
Well, given that he won't answer the questions directly, for now he is to remain in this courtroom.
I'm requesting to not be in this courtroom.
But you won't answer my questions regarding that, sir.
I did. I told you I don't understand.
That's not answering the question, sir.
You asked me a question, I answered it. I don't understand. How can I answer something that I do not understand, Your Honor?
All right, let me start with the jury instruction.
You'll
There
start
is
with,
one I
you
would
start
like
with subject
to.
matter jurisdiction?
No, I've declined that already, sir. I'm not going to address
Under
that
what
further.
law? Under what lawful law?
Sir.
Okay, so
please
now
do
he's
not
just trying to
interrupt
get
me
kicked
again
out.
with the topic of subject matter jurisdiction, or you run the risk of forfeiting
The
your right to be
old-fashioned way.
present in this courtroom.
Then let me go in the other courtroom then.
Are you willing to engage in a discussion about that, sir? I need to make an appropriate record.
I just told you that I don't understand the questions you're asking. What do you want me to do? I can't answer something I don't understand.
I believe you're choosing not to answer them,
You can
sir.
believe what you want to believe. I believe that you hiding stuff from the jury. I believe you haven't been impartial or fair. You haven't let me even enter anything into evidence, which is my right to do so.
Your
But it
rights
doesn't
are not
matter what we
unfettered,
believe,
sir.
Your Honor. I'm merely stating a request to not be present for these proceedings. I cannot answer the
Sir,
questions you are asking me
It
because I
seems to
don't
me
understand them.
You understand your right to be present in the courtroom. Are you telling me you
I don't understand
that right?
anything. Nope. I don't understand. Nope.
Then you're going to stay here for now.
And under what lawful law? You can't force me to stay somewhere that I'm making a request not to. You can't make me understand. You can't force me to understand what I don't understand. You can't force that.
I need to address one of the jury instructions, number 315.
So, Your Honor, I'm trying to make a request to not be present in these matters without disrupting the courtroom, as you say that I do, and over talking you as you state that I do. I'm making a request merely to not be present for these proceedings.
Which you just did.
Obviously, I'm not needed because every decision that's been made here today has been made without my consent. That's clearly telling me that I'm not needed. I have never consented to anything that's going on here today. I haven't even been allowed to present any evidence, which is something that I stated weeks ago.
This is groundbreaking right now. I can't believe it. I think he's almost starting to get some things. I mean, I know this is all just an attempt to like make her feel bad in some sort of way. But I think he's starting to understand, this is all to just get you in prison. We don't really care how you feel about any of that. So Yeah, I don't know.
Weeks. You already knew, Your Honor, that I wanted things to present into evidence. I've asked numerous times for that and have been denied. And I don't understand why I'm not being able to adequately defend myself.
In your words, you're not being allowed to adequately defend yourself based upon your conduct in this courtroom and throughout these proceedings, and your unwillingness to follow the simple rules of decorum, courtesy, procedure, rules of evidence. You refused to answer a variety of questions this morning when this court went through or attempted to go through the colloquy with you regarding your right to testify and your right not to testify. And because of that, and based on the case law that I cited this morning, I made a finding that you forfeited your right to present further testimony and evidence through other witnesses, and then you forfeited your right to testify in your behalf. I'm not going to revisit those, sir.
I'm not asking you to revisit them, but I'm just, they weren't correct.
I understand you will
because
disagree
I
with
never
that.
consented to it, and I never answered something.
I understand
and
you
I
did
just
not
stated
consent
the
to
reason
that.
why I didn't answer, because I don't understand. You cannot force me to understand what you're asking me.
Sir, I could not even get through the advisement. You wouldn't even listen. You talked over me repeatedly.
Was that from the other courtroom or in here? Because I've been over there all morning.
To the place that you are requesting to go back to, right?
You sent me into the other courtroom.
You're right, I did.
Right. So I've been over there all morning.
With an adequate audio and visual system connecting the two courtrooms.
Your
functional equivalent
to
of being
your
present in this
equivalent to
courtroom.
your equivalent is adequate, but to mine it's not. Seeing as how you always state Illinois versus Allen. You always state that. You always state that. But it never refers to a fourth option that you refer to. It never
Mr.
refers
Brooks, I'm
to
not going
that.
to debate this with you. If you continue to bring up subject matter jurisdiction, Illinois
I
versus
didn't bring
Allen,
up subject
the
matter
decisions that I
jurisdiction.
made earlier,
I'm trying to figure out why I'm being held in
you are
contempt.
frustrating the purposes of this hearing
I'm trying to
right
figure
now,
out why I'm being held
which
in
is to
contempt.
finalize the
And
jury
then when
instruction and the verdict forms.
Your Honor, I'm merely trying to understand why when you hold me in contempt,
I never held you in contempt, sir.
you attempted to.
Nope.
You've never attempted to hold me in contempt.
No, sir. I'm not going to revisit all of these issues.
When I asked you where you hold
Are
me in
you
contempt,
going
you
to
said civil.
respect the decisions that I've made
They're
by
not
not interrupting
they're
me?
not correct decisions, Your Honor.
I understand that.
I can't answer.
He's telling the
You
judge
asked me
her
questions.
decision.
You asked me questions. I didn't answer them based on my understanding. How can you force me to understand what you're asking me if I don't? And then you still make a finding based on that. How is that lawful law?
Mr. Brooks, I stand behind the record that I've made today.
And that's fine. I'm not
advising you
arguing
that
with
if
you
you
about what you
continue
rude.
to talk
I'm saying
over
how
me,
can you do that without my
If
consent?
you continue to raise issues that I've
That's
already
a violation
addressed,
of my civil rights.
if you continue to raise these issues, sir, and thwart the purpose of this court, which is to finalize the jury instruction and the verdict forms, you will forfeit your right to be present in the courtroom, and you will appear from the other courtroom.
Okay.
Absent you, I know
And
you've requested to be there.
I made a request the moment we walked in here to not be present for these proceedings, but yet
But you
still,
also won't have a dialogue with me about your understanding
because
of what that
it's my
means.
Fifth Amendment right. I'm exercising my rights that I reserved from the moment we walked in here this morning. You can't force that. You can't force me to do anything, actually.
No, you're right, but I can make certain findings that you forfeit rights
You
that
can't
you have based upon your
based on
conduct.
what lawful law, Your Honor?
I've cited the law.
Lawful
this morning,
law is
right?
not-
I am moving
Illinois
on.
versus Allen, right?
I am
That I
moving
can
on.
be present from another courtroom.
I need
if I
to
forfeit
discuss
my right-
instruction 315.
Your Honor,
because
I don't
believe some
understand.
language needs to be modified based upon the court's earlier ruling today.
I don't understand. I don't understand the proceedings. And I think that should be stated for the record. If I'm telling you repeatedly, Your Honor, that I don't understand. You can't force me to understand. That's a violation of my constitutional rights to try to force something upon me. That's coercion, Your Honor.
Oh, no.
Mr. Brooks, I completely disagree with your characterization of the proceedings this morning. While it is true that you did not provide consent, you were entirely uncooperative with court this morning.
That's because I didn't understand. I'm explaining why, Your Honor. I'm not trying to leave it where it was at. I'm attempting to
answer the questions.
I'm attempting to
I'm going to
explain myself of why I did not answer. It was because the way that you're making it seem is that I intentionally didn't want to answer, and that's not fair.
I'm moving on to instruction 315.
And I still don't understand. So how can we even proceed,
Mr. Brooks?
If I'm telling you I don't understand
what that I'm asking you to be?
No, I don't. No, I don't.
Mr. Brooks, please stop interrupting
And for the record,
me.
I don't consent to being called that name, Your
You
Honor.
clearly hear me, sir, because if you didn't hear me, then you wouldn't make that statement.
Hearing and understanding is two different things.
I know you can hear me, sir. I'm asking
Hearing
you
and
to
understanding
stop
is two different
interrupting
things.
me.
I'm not trying to interrupt you, but you're gonna, at some point, you're gonna ask me my opinion of what's going on, and then when I tell you I don't understand, it's gonna be taken as me trying to delay or trying to do this or trying to do that.
I will explain why I'm bringing up instruction 315.
And I'm not gonna understand your explanation.
Well, you can't say that if you haven't heard what I have to say.
He
you
already
tried to do this
knows.
earlier before lunch.
But I need to clarify something, because 315, which is the instruction that has it's titled Defendant Elects Not to Testify. I had it in there. However, that instruction should really only be given if requested by the defendant. There has been no request made. And obviously this court made a finding that he forfeited his right to testify. And absent Mr. Brooks requesting that instruction to be in, I believe it would not be proper for this court to include 315 in the instructions to the jury. Does the state have any position on that?
Your Honor, I did look at the notes that are associated with instruction 315, and I would agree.
All right. Mr. Brooks, do you have any position on whether this court should include instruction 315 in the jury instructions to the jury?
I don't even understand what 315 jury instructions.
I knew it.
It's entitled Defendant Elects Not to Testify. I'll read it for you.
Okay, so we have unlocked a new angle. I mean, even though he said this pretty much all throughout the trial, I guess now this is his main tactic for right now, is that he just doesn't understand, which I'm sure he doesn't understand it, but that's the reason why it's his fault. I mean, he had court-appointed attorneys who he fired. So the fact that he's sitting here now and he's frustrated, it's all by design. Yeah, it's just ridiculous that he's actually trying to use this. I mean, we all know this entire thing is an act.
My notes, meaning my materials, my jury instruction book, says to be given only if requested by a defendant, and it reads as follows. This is the actual language of the instruction. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. So my question is, do you want this instruction read or modified in any way?
You just said I got a constitutional right not to testify or to testify. I didn't make either one of those decisions, so I don't understand.
The jury instruction is typically read when a defendant does not testify. In every other case that I've had, the decision on whether to testify was a decision made by the defendant personally. In this case, the court found that you forfeited your right to testify based upon your conduct.
He does not like that word.
That's the ruling I made this morning.
How did I make that decision, though? I didn't.
My question to
never say
you
yes or no.
is,
I never
do
say
you
yes or
want
no.
the jury instructed that your silence must not be considered by them in any way and must not influence their verdict in any manner?
What do you mean my silence? My Fifth Amendment right?
Correct. I'm not hearing a request from you to have the jury
because
given this instruction.
I don't understand why you're asking me the question, Your Honor. I never decided to or not to testify. I never decided either way.
I understand that.
So how can I answer that? I don't understand why. I don't understand.
We are now at the moment where we are discussing whether the jury should receive an instruction specifically on you not testifying, irrespective of the reason for that. I believe I could modify this instruction to simply say a defendant's silence or a defendant not testifying should not be considered by the jury in any way and must not influence their verdict in any manner. Are you making such a request for a modified instruction?
I don't understand the question because I never decided to or not to testify.
I understand. I understand what you're saying, sir. I really do. But in light of the court's decision that you forfeited your right to testify,
how did I forfeit something I never said?
Do you want the jury to be instructed something to the effect of they cannot use your silence, meaning they cannot use you not testifying against you in any way?
I don't understand because I never made a decision not to or to testify.
I'll ask you one more time, and if you do not answer with a yes or no, I will take your answer of not answering as you are not making a request for a modified instruction.
How can you do that,
Do
Your
you
Honor?
want this court, sir, to instruct the jury in any way regarding you not testifying in this case?
I don't understand the question.
All right, then based
I don't
upon there has
understand.
not been an express request made by Mr. Brooks to give either 315 as it's in the standard or pattern jury instruction or a modification as this court has suggested, 315 is to be taken out of the jury instructions.
How are
Nice.
all these decisions being made without me understanding?
Because your lack of understanding doesn't just change the entire process. But he's really having trouble understanding that part. It's like, you can tell that was his reason for getting rid of his attorneys. He was thinking that he could just go throughout this process saying, I don't understand. And then everything comes to a screeching halt and no one can do anything because he doesn't understand this. Okay, I don't even know what to say right there. I'm stumbling over my own words because I don't even know really what to say about that.
And I have
But it's just silly.
over the verdict forms, and other than really what I would describe as some consistency in how phrases, whether there's all caps, not all caps, but
All caps.
what we call the sentence
Like the name that was
capitalization
on
for
there,
the
all
charges. For example, I want to be consistent with how I spell out first degree intentional homicide or first degree recklessly endangering safety. There was just sometimes it was capitalized, sometimes it wasn't. So we're looking through all of that to be consistent. I want to make sure the word information is capitalized since that's the charging document, things of that nature. It is my practice, and you should be aware, Mr. Brooks, that I always put the not guilty verdicts on top when I hand all the verdict forms to the jury. And by that I mean it's by charge. So they're collated, if you will. So the not guilty followed by the guilty for counts 1 through 76.
You said it's collated. What do that mean?
So I put the not guilty, then the guilty for count 1, followed by the not guilty and the guilty for count 2, and so on and so forth, all the way through the remainder of the counts that are alleged in this case, which in this case total 76.
I don't understand. So how?
I looked at the special questions
Will you
that
answer
are
that, Your
on the
Honor?
guilty verdicts only. They did appear to be proper. Again, just some.
Sorry, I love this right now that she's not acknowledging him. And she's just kind of speeding past him.
But I believe those are all accurate.
Can
I'll
I go to
turn
the other courtroom?
state.
Since you don't have to answer any questions, but I have to answer all, can I just go to the other courtroom?
Not at this time.
Why not? I keep telling you
'Cause
I
you're a
don't
man-child.
understand these proceedings, and you just keep running right over my rights, like you don't even hear me saying anything.
Attorney Basie, are you handling the verdict forms? Go ahead.
Can I go to the other courtroom, please?
Are you waiving your right to be present in this
I'm
courtroom?
not waiving anything.
Then the answer is no.
I'm making a request.
Then the answer is no.
Then how's it? So what? You gonna try to force me to interrupt and do all this so you
I'm
can
not
make the
forcing you,
record
sir. I'd
and
like
make
you
it
to be
seem like
here.
I forfeited something that I came in here as soon as we got on the record and made a request to not be present for these proceedings. But when I'm making a request to avoid the drama and all that,
Sir, the only one with the drama is you.
it's you too. You the big contributor to the whole thing.
That's perfect.
Mr. Brooks, I have to preside over this case.
Yeah, and you haven't been impartial or fair yet.
Mr. Brooks, I have a question to the state. I ask that you not interrupt. And that
It's not about me interrupting. It's about me attempting to understand. I've been saying that since we came in here.
Mr. Brooks, I
You
will
can't
respond
force me to
as follows
understand.
to that. You waived your right to counsel.
I didn't waive my right to no counsel. I gave you the
waived your
contract.
right.
I did not. And you won't sit here and say that for the record, because that is not what happened.
You are
No.
incorrect.
So we don't have do we have the paperwork? Because I believe that I gave you the paperwork back that you...
Mr. Brooks, you
I gave it to you, altered,
clearly
and did not waive it.
have been presenting a nuanced argument regarding
That is
the
not
right
true,
to
Your Honor.
counsel
That is not
versus
true.
the right to assistance of counsel.
That is not true.
That's a pretty sophisticated argument. That's why I believe you fully understand what's going on in this courtroom.
I don't fully understand.
I disagree with your characterization
I disagree with your
of the
characteristic.
right to counsel.
You know that you accepted
You
the way that I
waived
gave it to
the
you.
entirety-
So you shouldn't have did that if you had questions of me not understanding.
I don't have any questions whatsoever.
You definitely
sir.
do, because I'm telling you right now I don't understand, and you still won't even acknowledge the fact that I'm saying in open court on the record that I don't understand something. I haven't waived anything. You made decisions today that I didn't consent to, that I explained I did not answer because I didn't understand, which is my right to say that.
Right, Mr. Brooks,
It
you
is
are
also my Fifth
interfering
Amendment
with the
right to be
proper and
silent.
orderly administration of these proceedings. I understand that you disagree with the decisions that I have made, but you aren't respectful of the decisions. You keep wanting to debate them and argue them. That is not the proper legal recourse at this time. I have asked you if you're willing to waive your right to be present. You indicated you're not.
Because
and
of
yet
the way
you continue
put it.
to
You said
interrupt.
waive. I'm not waiving anything.
Then that's why you're here until I make a finding that you, by your conduct, are forfeiting your right to be present.
Well, make the finding and kick me out. Make the finding and hold me in contempt.
I mean, the fact that he's pretty much screaming over her this entire time, I think it's a good point to kick him out. But he's definitely going to just try to ride this day out with this angle of I don't understand. You can really see, like, now he's putting it at the forefront. I don't understand, so now we just have to stop. That's not their problem. Like, it's not we all need to gather around him and make sure he understands what every word means. When you made the choice to be in this spot, I'm just happy that this is the decision he made, because he made it so much easier to go to prison. So that's the only thing that I'm happy about.
That's why that courtroom been set up the way it has for the whole time, because at some point it's anticipated that I will be over there. Which is not impartial and which is biased. It's judicial misconduct.
I stated from the beginning, sir, that the goals of this trial.
So you reading from
Are
the paper, or
threefold.
are you reading, or are you just citing what you know?
Number one, sir, is during the evidentiary phase of this was to control the presentation of evidence so as to ensure fairness and reliability of the criminal trial process.
And I offered
That
evidence that you
includes
didn't allow.
developing relevant facts upon which a determination of guilt or innocence can be made. What is sometimes referred to in the case law as the ascertainment of truth. There's an equal but secondary purpose related to efficiency and effectiveness. That has been my repeated use of 906.11 is what that would fall under. There's a third goal of everything that I've done here, and that is the courtesy and decorum in this courtroom, what I've sometimes referred to as civility. Of course, there are other goals as well, including protecting your rights, protecting the record, protecting the jurors.
How have my rights been protected, Your Honor, if I can't even put evidence into
Disagreement
it?
with the
I
court
can't even make evidence.
decisions, sir.
Yeah, but how can I defend myself if I can't even present evidence?
But sir, you have not been
Because you
willing
don't know
to
how.
follow the rules of civility
But
and
that doesn't
decorum
have
and
anything
trier.
to do with my evidence.
It has
I could have
everything.
did that from the other courtroom too, correct?
Sir, you...
If I can
by
be
your
present from the
conduct-
other courtroom, I should be able to present evidence from the other courtroom as well.
And you, by your conduct this morning, sir, are
I'm
not
saying-
willing to
I'm
answer
saying-
the
I'm
most
saying
basic of
totality.
questions
The
about
totality,
whether
Your Honor. The
you
totality.
had a witness available.
Have I not asked, in fairness, have I not asked to admit evidence? Have I not asked more than once?
Mr. Brooks, you have not asked to present any evidence.
Yes, I
in a
have.
legally
You told me we weren't at the
cognizable
evidentiary phase.
manner.
How would I know that if you didn't answer,
And you,
answer the question?
as your own attorney, you proceed at your own peril sometimes.
That
Whether
has
you have a
nothing to do
full
with me
understanding
presenting
of the rules of
evidence.
procedure and rules of evidence or not. And
That
I
has
made that
nothing to do with me
abundantly
being able to
clear.
present evidence.
So, Mr. Brooks,
Nothing
this is your
I
final
presented have
warning.
been able to be admitted into
I am
evidence.
turning to the state for a discussion of the verdict forms. If you interrupt me or them again, then I will make a finding that you forfeited your right
Make
to
the
be
finding.
present,
Make the finding.
and you will appear from the neighboring courtroom.
You want me to appear from the neighboring courtroom?
I don't.
Just let me go.
Attorney Basie, go
Just
ahead.
let me go.
I felt that all the verdict forms looked good. I did ask your
This is
clerk.
ridiculous.
All right, he's interrupted. He's
There
forfeited
you
his
go.
right to be here. He's chosen to do that despite the warning from the court. Will be
There
in
wasn't
recess
no
until
warning.
he's
I'm the one
taken
that asked.
over
So let's
to the other
make the record
courtroom,
correct.
and we
I'm
have
the one
the
that asked
audio
when we came in here, Your
and
Honor.
video working
I
appropriately.
asked when we came in here to
Madam
be
Clerk,
present
we'll
from the
have
other
to do it by
court.
Zoom because we may have to utilize the share screen in order.
We
for
don't have to
the-
utilize no serious screen because I'm not going to participate in no proceedings that I don't
The
understand.
documents.
I told you I don't understand
We're
a
in
million
recess until
times.
we get the courtroom set up.
No, we don't have to be in recess. I don't agree to it.
Estoppel is what he was about to say. Yeah, so it's pretty clear that that's the angle that he's going to take here. But I'm going to fast forward to when they get him loaded up in the other courtroom. This whole day pretty much has just been him appearing from the other courtroom.
Mr. Brooks is now appearing from the other courtroom.
All right.
Appears he has headphones on. Speaking of headphones, I do need to make a correction to the record from this morning. I had made a statement that, given his demeanor, the headphones had been taken off the table by the bailiffs. I was incorrect. Mr. Brooks handed the headphones to the bailiff, saying he didn't want to break them. All right, so we are discussing the verdict forms. Go ahead, Attorney Basie, you can complete your record.
All the verdict forms looked good. I did notice, I think it was actually the way that a misspeed. For count 15, I have a not guilty verdict. I did not have a guilty verdict, but the way that it was on the paper made me believe that something happened, and I think you probably have it with your packet, it just didn't get printed off for me.
We'll make sure that that's there. Any misspellings of any names?
I did not see any.
All right.
And now here we go for the clown show portion
All
of
right,
this.
I did.
She has to
When
ask him
we
his question.
Started up the video conference. Mr. Brooks has been muted. I am going to unmute him right now. And I should state again for the record, all of the verdict forms, or at least the drafts, were provided to him prior to the lunch break. So he would have had an opportunity to review them should he have chosen to do that. Do you have any position on the verdict form, sir?
I wasn't provided with anything, and if I was, I accepted and returned it for value. And since I'm now in another courtroom, are we going to address subject matter jurisdiction? You have yet to prove it for the record.
Mr. Brooks, you were provided with the verdict forms. What you did with them, I don't know.
Again, I haven't been provided with anything.
They were provided to you prior to lunch, the lunch
I haven't
break.
been provided with anything.
Teresa, you had the large packet of verdict forms. How were they given to Mr. Brooks prior to the lunch break?
By hand to the bailiff, and the bailiff to him.
To be, and the bailiffs are confirming that the verdict forms were provided to him on his table.
Of course.
I will remind you once again that I do, it is my practice to put all of the not guilty verdicts on top of the guilty verdicts in a collated fashion. Again, I saw a couple of just cleaning up, I would say, not with the words themselves, but just capitalization of various words within the verdict forms, and I'll make sure that's done. The appropriate counts had and have the appropriate special verdict questions. Those special verdict questions are only as they relate to guilty verdicts related to the use of a dangerous weapon for counts 1 through 6, the homicide counts, and then 61 through, I believe 60.
It would be 7 through.
7 through 67 have that special verdict, and then the hit and run counts have the special question related to did each of the counts involve the death of a person, and it names the person alleged to have been killed. So those look to be all in order. I've already addressed, going back to the jury instructions 315. We have done a little bit of rearranging some of the order, but the content is there. It is my practice to read through all of the instructions up until the point of closing arguments, and then I stop. Parties are given their opportunity to argue the case to the jury, and then following that there are what I like to call the closing instructions, or which are still quite lengthy in this case given that they go through the verdict forms specifically. And then of course the alternate jurors would be selected. But given...
Am I muted?
No, you're not. You haven't been.
So I got a question about the enhancement for use of a dangerous weapon. How is that being charged? Is that under 939.632?
It is in the charging document, sir.
How is that being charged? From my understanding, that the statute reads the increased penalty provided in this section does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charged. Without the vehicle, there is no crime. So that would apply. So how am I charged with?
State want to is your argument only as it relates to counts 1 through 6 or others?
Whichever count has the enhancement penalty for use of a dangerous weapon.
Well, that would be all of the intentional homicide charges and all of the first degree of recklessly endangering safety charges, so counts 1 through 67.
So 1 through 67.
Correct. I can have the state respond to that.
Yeah, how is the alleged defendant being charged?
So are you asking how are you making a specific request as it relates to the special verdict question?
He has no idea.
I would say both.
I'm so sure he doesn't even, he doesn't even understand what his own question is right now. He's just tossing out whatever he can think of. But what a weird statement. Without the vehicle, there would be no, he says something like that, without the vehicle, there would be no charges or something. Because you use the vehicle to do all of this, all the damage, all the carnage that he caused. But it's,
I don't
okay.
understand how.
Makes no sense.
That's why there's the question. Reading the statute.
And which part of this, I'm sorry, which part of the statute are you referring to again?
I believe it's 939.632.
And your specific argument is what again?
How is that enhancement, how is the alleged defendant charged with that enhancement when reading the statute it says it Well, I just read it, so.
I believe you refer to sub 2, which states the increased penalty provided in this section does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge.
Right, that's what I just read, Your Honor.
Well, what's the state's response?
Using, possessing, or threatening to use a dangerous weapon is not an essential element of either first-degree intentional homicide or first-degree recklessly endangering safety. If it were, it would be one of the elements in the standard jury instructions, and the defendant can see it is not. This is different from a situation like armed robbery, which does require the use or threatened use of a dangerous weapon. So the penalty enhancer is correctly charged for those two types of crimes.
Any final argument on that, sir?
Yes. That's not what the statute is clearly saying. It's clearly stated. It does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge. If there's no vehicle involved, where is the crime? It has to be an essential part of it to even be a crime.
This is absolutely ridiculous. I'm not going to keep it paused for super long, but this is absolutely ridiculous. He has to know that this makes no sense. Without the vehicle, there would be no crime. That's true. Without the vehicle, this wouldn't have happened. So I don't really understand what he's arguing right now. Okay.
The alleged defendant is charged with using a vehicle to commit these crimes. If there's no vehicle, where's the crime? So it has to be an essential element of the crime. Otherwise, there's no crime. I think it's the essential element. If you read in the statute, it's the essential element. You can't just walk up to someone and quote unquote run them over. There has to be something used in order for this alleged crime to transpire, and that would essentially mean the quote unquote dangerous weapon. So without the quote unquote dangerous weapon, where's the crime? So how can it be charged when it is the essential element of the crime charge?
Well, sir, I've listened to your argument. I've read the statute. I've looked at the elements for intentional homicide and first-degree recklessly endangering safety. Neither one of those crimes have as an element in it use of a vehicle. There are certainly many different ways that both of those statutes can be violated. While it's true that in this particular case, the use of the vehicle is the mechanism or instrumentality that's being alleged to have been used, but it's not the same as being an essential element of the crime. I think the armed robbery crime is a good example of when you could not face an enhancer for use of a dangerous weapon because you can't have the crime of armed robbery without the threat or use of a dangerous weapon. And so
that's the same argument.
Okay.
Your Honor. You can't have this alleged crime without the use of the vehicle. It's the same thing.
it's not an essential element of either first-degree intentional homicide or first-degree recklessly endangering safety. So I'll deny the request to strike the enhancer for those reasons and find that it is properly before the jury for their determination.
He's not going to let it go that easily.
I respectfully object to that, Your Honor.
Understood. Do you have any other challenges to the verdicts you'd like to raise at this time?
Yeah, would that be, will my objection to that be noted for the record?
It is.
May I request a legal reconsideration of your ruling, Your Honor?
Denied.
May I request a written finding of fact for your ruling, Your Honor?
Denied. Just for the record, it's my understanding that the verdict forms were put in the garbage by Mr. Brooks and they remain in there. That was provided to me by the bailiffs.
May I respectfully request a written judicial
Absolute
finding of
clown.
facts and conclusion of law for this issue, Your Honor?
You may request it. The request is denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
This is not the proper court to grant such relief.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Your request is denied.
Based on what law or fact?
Your request is not based in law or fact, sir.
I just read a statute that it came from. My argument was based on a statute, a Wisconsin statute.
Your request is noted.
This is
Your
absolutely
objection
ridiculous.
to the court's finding and determination is noted. I decline to issue any type of written decision or stay pending appeal, noting there is no appeal that has been filed.
May I let the record show that this court will not allow the accused to adequately defend.
This is insane that he's in the other courtroom right now and he's still running his same routine, reading off of that paper. Oh my goodness, the mute button has never seemed so great right now. I'm really hoping that I know Judge Darrell's trying to give him his. I honestly don't know. I don't know why she's entertaining this right now. I really hope that the mute button is used very soon.
Themselves in this matter.
The court's already made its findings regarding the forfeiture of right to testify and the forfeiture of the right to present additional evidence and testimony. I'm not going to revisit the same.
Which was not consented to. I never stated that I did or did not
Understand.
want to testify.
I understand.
So how can that decision be made on my behalf when I didn't say either way? What I stated was I didn't understand the questions being answered.
Sir, do you have any other questions or issues regarding the verdict forms?
Your Honor, are you making a judicial determination that you don't have to answer any questions?
I'm not answering those questions, sir, other than how I've already answered them.
Is that a judicial determination?
Sir, every decision I make is a determination by this court.
Is it a judicial determination?
Sir, I will ask you once more. Do you have any other issues
and I will
to
tell
raise?
You once more, I don't understand the questions that you are asking.
Sir, do you have any other issues to raise with respect to the verdict forms?
I do not understand the questions that you are asking.
He has now twice not answered the question. I'll ask one last time and specifically advise him that his failure to answer the question will be taken by this court as a no. Sir, do you have any additional...
Under what law of fact can you say no?
Sir, do you have any additional issues to raise with respect to the verdict forms?
I do not understand the questions that you are asking.
All right, he has chosen not to answer other than by saying he does not understand the questions. He did not specifically answer with a yes or no. Therefore, this court takes that as he does not have any additional issues to raise with respect to the verdict forms.
That is incorrect. I stated I don't understand. You can't force me to understand something, Your Honor.
Right. Did the state have any other...
It is my
I'm going to mute him momentarily. Mr. Brooks, I'm muting you because I'm moving on to another topic. I understand you disagree with the court's rulings, but you need to respect the rulings with proper etiquette in this courtroom, which you are demonstrating once again you're not willing to follow, so I exercised my ability to press mute. Does the state have any other...
Nice. Yeah, that's a personal problem.
Relates to the jury instructions? I want to kind of full circle back.
He doesn't understand.
To approve of them.
Yes, we do not.
All right, Mr. Brooks, I'll ask you the same question. I will unmute. Do you have any additional requests as it relates to the jury instructions?
Yeah, I have questions related to all of them because I don't understand any of this.
My question was not do you have questions, but do you have any requests?
And my answer was I don't understand. and I've made several requests.
The requests are not related to the jury instructions, which is the phase of this hearing that this court is attempting to conduct with you and give you the opportunity to fully participate. Mr. Brooks is choosing not to answer my questions. I'm going to mute him momentarily, sir. I will ask you one more time.
Yeah, he's not understanding. That's a personal problem. The fact that you don't understand this and you chose to be here and to represent yourself. I know I'm just repeating what I said a second ago, but that's a personal problem. No one cares about that. I mean, we never cared to begin with, but
if you have any requests as it relates to the jury instructions, I then will ask you if you approve of the jury instructions. If you do not answer those questions as it relates to the question, do you have any requests as it relates to jury instructions, I will interpret that as a no. And if you do not specifically answer the question about the jury instructions, I will interpret that as your approval. So first question to you is, do you have any, and you're unmuted, do you have any requests at this point as it relates to the jury instructions?
And I just said before, I said I do. I said I don't understand the questions. Of course I have questions if I don't understand.
So do you have any
That's common
requests
sense.
for any additional instructions that are not included, or to remove any that are included?
Yeah, remove them all until I understand, or add the jury instructions that I have myself.
What jury instructions do you have, sir?
So now you don't know I had jury instructions, and I told you this weeks ago.
What filing are you referring to, sir? If I've overlooked that, I will certainly reconsider, but I'm not aware of a specific jury instruction.
It seems like you overlook a lot, Your Honor.
Can you point me to a specific filing?
So you have all my
not.
filings on file? Are you saying that you have my filings and they haven't been admitted into evidence?
Oh, my computer's not working.
Oh, now the computer's not working.
how much do you want to bet he just
Sir,
wrote?
please direct me to the specific filing that you're...
How much do you want to bet he just wrote like jury instruction don't include or something in an email or just on a piece of paper, just in bold letters, don't include jury instructions? It's just going to be something so cartoonish. Like, that's how he does everything. It's almost like a sitcom. Like, I mean, of course he's not a sitcom character. He's extremely dangerous. But it's almost on that level of, like, the comedic timing of this when they open up some of these emails. It's all ridiculous, but...
referring to that has a request related to jury instructions.
You just said you was referring to the filings. Right? Did you just say that?
That's not what I said.
Did you just say what filings are referring to jury instructions? Did you or did you not just say that?
I said, do you have a specific filing you can refer the court to that relates to jury instructions?
So is your computer working or is it not working?
It's being a little temperamental, but I just can't use my search function. So if you can direct me to a filing, that would be great.
It would also be great for those filings to be admitted into evidence.
Oh my goodness. Yeah, there's no filing. Let's just move on.
Sir, simply filing something with the court does not make it evidence during the evidentiary phase of a trial. There are rules of procedure and rules of evidence that govern that.
And you told me
he knows that.
All my filings in writing.
Sir, I said if you had a motion, it needed to be put in
all
writing.
Those were motions. All those were motions.
Sir, what filing are you referring the court to?
Look through all my motions.
Sir, it's not my job to advocate on your behalf. If you have something in particular... Sir,
I asked you to do your job.
Sir, if you have something, a specific request, now is the time to make it.
Well, how about this? I don't accept none of those jury instructions. I don't accept any of them. Any of them. And again, I'll tell you, I don't understand. Why do I have to keep saying this when it's clear that I don't understand?
Your Honor, I can inform the court.
Hopefully he'll understand that 700
jury
years
instructions were
is coming
due,
up soon.
I believe, on August 30th. The state submitted their proposed jury instructions as well as the substantive instructions, and the defense indicated that they agreed with our filing. So I don't believe that there's ever been a request for any different jury instructions than what have been filed with the court.
So what jury instructions are you referring to, or what document is being referred to on the alleged defendant's behalf? Because as we all know, I didn't obtain the discovery in full until the end of September. So there was documents that I didn't even know that existed.
Mr. Brooks, one final time, do you have any specific requests as it relates to the jury instructions other than your request that they all be struck?
And I'm telling you, Your Honor, I don't understand the question. I can't.
All right, then I will take his response that he does not understand, that he does not have any additional requests.
I didn't say
And
that.
they will be
I said I don't
approved.
understand.
They will be
can't-
approved and are,
No.
I'm going to have to mute
No.
him. They are approved as been drafted by the court and modified during the jury instruction conference on the record this morning and this afternoon. I will once again review all of them just for grammar, just to make sure all of that is correct, and provide a written printout of the final draft for the parties before we break for the day today. I am also approving of the verdict forms that have been previously submitted to the parties, just noting there's just a few grammatical things that need to be corrected, but the content and substance are there, and I've already addressed on the record any requests by the parties this afternoon.
All right.
No, Your Honor, I believe that the final copy that we've been working off of is appropriate.
Any comment about that, Mr. Brooks, or any statement?
I don't consent to being called that name, and I've just told you I don't understand these jury questions. I'm not going to know how they allowed to pass just because you feel that they should. When I'm telling you I don't understand them.
She's the judge. You absolute clown. She is the judge. Like I said before, hopefully he understands that 700 plus years. I'm sure he'll understand that part once they read it out to him. I'm so sure that Judge Darrell is looking forward to that moment. She finally got the chance to tell him exactly what he is to his face. I mean, not exactly to his face because he's in the other courtroom again, but she got the chance to tell him exactly who he is, and then she gave him that 700 plus year sentence. Like, I know she's looking forward to that moment, but man, this is frustrating. Just to end off the day. In the last video I put up, I took a glance at the comments. You all were saying this is going to be one of the more annoying days because this is all he's going to do pretty much. So, okay, buckle in. And we literally have like 30 minutes left. But you know that 30 minutes is going to feel like an hour. So I'm just going to let everyone know, buckle in right now. This is going to be stressful, as it tends to be. And I'm trying to take up time because he is the most annoying human being on earth. But okay.
I would note that
Not one of those jury instructions came from me. Not one. How's that fair?
Mr. Brooks, this court gave you the draft of the jury instructions. I need to mute you because, once again, he's debating about things that I think are very clear on the record. This court provided both the state and Mr. Brooks with a written printout, 107 pages long, of the jury instructions it was considering in this case.
Right.
We had a discussion this morning. We continued that discussion this afternoon. prior to breaking for the lunch hour, all of the verdict forms were printed off and provided to both the state and to Mr. Brooks. It is also true that when he was previously represented by counsel, the court had some specific deadlines related to jury instruction proposals, and the state reminded me that there essentially was not an objection raised regarding the proposal and the filing from the state. I had a brief opportunity to look through the record of the inmate communication forms that have been sent during this trial that are on file. I haven't seen anything that references jury instructions. I'm well aware that he has other filings, but I could not find anything related to jury instructions.
Another
Any
lie.
specific
What a
request
surprise.
that he is making or made during this case.
Now the poor bailiffs have to listen to this nonsense because he has this pent
So
up
for the record, I am
aggression.
approving of the verdicts. I am approving of the jury instructions. And once again, before we break for the day, I will make sure to provide the parties with written printouts of both of the documents as they now stand. Then there are a few other issues we need to go through. Attorney Basie, I think you brought these up prior to the break. Maybe it was Attorney Opper, in terms of scheduling and what I would consider other housekeeping issues, but go ahead and remind me once again of the issues you wanted to bring up.
I don't know what he just did to
I
that
think it
thing.
was
Is
the alternates,
okay.
Sequestration, and there might have been a third.
Yes, Your Honor. The question is to the sequestration of the jurors once they are excused for deliberations, and should the timing require that, an overnight stay or something along those lines. We wanted to discuss that. We wanted to discuss what the court intended to do with the 3 alternates once they have been selected. It would be our request and position that they should remain in a secure location, separate and apart from anyone else, unless and until full deliberations are complete by the 12 selected to decide the case, so that if needed, and in light of the brief COVID history we have on this record, if needed, one of the alternates could slide into position of one of the 12 who are deliberating if that became necessary. So we wanted to address that, and then we just wanted to address timing generally for closing arguments, verdict returned by the jury, and then the court's intentions as to the rest of the week should there be guilty verdicts returned.
Sure. Before I address all of those, are there any of those final type of issues, sir, that you would want the court to address? You have been unmuted, so you can answer that.
Back to the delay game.
Mr. Brooks, do you have any of those final type of questions or issues that you want the court to address? You are unmuted. I am.
I just told you since nothing I say even matters at this point, I'm just gonna tell the jury what they need to know. I'm just gonna tell them the truth.
Mr. Brooks, you are
All right.
aware that your closing arguments have to be based on law and fact, correct?
They're gonna be based on whatever I'll base them on.
Oh boy.
Well, I trust the state will object when appropriate,
Well,
if
it's gonna
appropriate.
be a whole lot of objection then, because I'm gonna tell the truth. You haven't allowed. You just been making all the decisions for me, even though I told you repeatedly that I don't understand, and you still make decisions based on my behalf without my consent, without me. I'm telling you I don't understand, and you still make a decision determining my life.
That's right.
Are you telling
Sounds
me,
about
sir,
right.
that you will refuse to follow the simple rules of decorum, courtesy,
If it ain't-
civility,
no,
the rules of evidence, and
don't try to come
the
with
rules
your
of
slick
procedure?
words. Don't try to come with your slick words, and don't put words in my mouth.
sir, I am not being slick. I'm trying to
You've
preserve the integrity.
you've been slick. You've
All right.
been slick.
All right. I'm going to mute you, sir, since what you are saying is not productive. It is not courteous. It is disrespectful.
I don't care.
I
what
need
you
to
think.
I need to go
I don't
over
care
these.
what you think.
All right, I'm muting him because I need to go over these important issues that have been raised by the state. So as far as the alternates, I do think it is important to keep the alternates who in a secure location, even if that means an overnight, unless and until verdicts are reached in this matter, and I will so instruct the clerk of courts to make those arrangements. We have been doing that all along in any event. As far as selecting the alternates, obviously each of our jurors have a number. I intend to have pieces of equal size pieces of paper made, folded up with each of their numbers, put them in the same turnstile bin that we utilized for the selection of jury preemptory strikes by lot, and to simply pull out 3 names. Those will be the alternates, and then or I should say not names, the numbers, and then the numbers that are remaining would be those 12 who will deliberate. And so I'll make sure that that's out here for the appropriate time. As I indicated this morning, all of the jurors were provided with some information regarding sequestration. It is the practice of that I've approved in this case that the jurors provide us with certain emergency contact information so that we are able to get a hold of families should there be the need. They're given information regarding sequestration, the purpose of it. If I have not made that a part of the record, I will make sure to get a copy of that filed in this case so that both sides know what was provided to the jurors today before they left. And then I'll also make sure that when the 12 are deliberating, that the 3 who are not are taken to a different jury room with a bailiff, and again, kept in a secure location, but separate from the other 12. In the event one would be needed, we would then take up that issue at that time, but I think it's good practice to have them available if that becomes an issue. As far as timing, I'll first address, I have instructed the jurors to be back at 9 a.m. That's because typically we have a few things to finalize in the morning, so we'll start at 8:30 tomorrow morning. It will also give the parties one final opportunity to read through the many, many pages of jury instructions and verdict forms to just make sure there aren't any other issues that jump off the page or that need to be addressed first thing tomorrow morning. But then I do intend to start with instructing the jury. This case will require a very lengthy time of the court reading off the jury instructions. I do believe it will require me to take some regular breaks, probably every 2 hours, until the jury instructions are read, with perhaps a longer break at the lunch hour. And my best guess.
Okay, sorry that I don't know why I keep double pausing, like that's really weird. But she's definitely going to need to carve out some time as well for all the interruptions that Darrell is going to have. I mean, unless she puts him in the other courtroom, like right away, which I'd imagine she's going to have to because he's not going to stop this. But yeah, it's definitely going to get dragged out much longer because all the interruptions he's going to throw in there.
Is that it'll take between 5 and 6 hours to fully instruct the jury. That's based on the 107 pages. Now, some of those pages, though, are after argument. And so that really kind of begs the question is, will the parties get to their closing arguments tomorrow, or will that be done Wednesday morning? I certainly would like to have the parties make their arguments.
Darrell wouldn't like that at all.
I see the instructions that we have thus far, the packet.
Which means I hope they get through them. I'm pretty sure they do.
Okay, thank you.
Since on day 15, they pretty much just bring in the families at that point and the victims. So I'm pretty sure they do get through that.
So the instructions that I read prior to the parties giving their closing arguments finishes on page 73. So given that, I believe that the parties will be able to give their closing arguments tomorrow. It just may be, depending on where that takes us, whether the final instructions are given the following morning. Because that's another 30 pages. I'd like to be able to do it. It just really depends on how late of an evening. I'm not opposed to going late, but letting the jurors go to the hotel and then starting their deliberations in the morning if that's what needs to be done.
Understood, and we'll be ready. I think from our recollection, it took you about 2.5 hours to read the preliminary instructions, which was 69 pages in length. So if that holds, I think, we reasonably could do closings in the afternoon, and it'd probably take you about an hour, hour and a half to read those remaining 30 pages. And we may still be able to wrap up by 4 or 5 o'clock in the courtroom.
I think that's a reasonable time frame. Do you have any estimation on the length of your closing? I'm contemplating maybe putting a time restriction for both parties. I mean, we had a solid 15 days of testimony, so I'm mindful that this is not a 30-minute closing.
Well, actually, I'm trying to keep it in the 30 to 45-minute range, just out of courtesy to the jury, Your Honor, and to highlight the important points.
Do you think it would be reasonable to give the parties each an hour total? That would reserve whatever's left from your initial for any rebuttal.
Yes.
All right, Mr. Brooks, do you have any position on that? I am unmuting you. I would note he takes the headphones on and off throughout. He doesn't have them on. He's looking at a book.
I wish you would stop saying book. I'm looking at the Bible. Thank you. It's not just a book. It's the book.
Can't disagree with you there, sir.
Yeah. How many people actually live by it, though? Anyway.
Sir, I've contemplated.
I'm just laughing at the absolute. This is okay. I'm not gonna pause on that.
Putting an hour time limit on closing arguments.
I ain't doing no closing argument tomorrow.
The closing arguments will most likely be tomorrow.
I'm not doing it tomorrow.
Okay, fine.
Then you'll forfeit your right to give one, sir, because as
You can't force me. You can't force me not. What type of court is this where you can say you're gonna force somebody not to be able to give a closing argument? How is that lawful law?
If you choose not to give one,
how is that lawful law?
Sir, if you choose not to give one, you're not letting me finish, and you're mocking me right now, which is incredibly disrespectful once again.
Okay,
you didn't even let me get my sentence out.
You always want to make an incorrect record. Go ahead. Make your incorrect record. Go ahead.
I'll mute him once again because clearly he just wants to be disruptive this afternoon. But as we have been talking about over the course of the last, 10, 15 minutes, talking about the timing of everything tomorrow, even though I have 107 pages of jury instructions, the first 73, I think, deal with what is read prior to closing arguments. That means the parties should be prepared to give their closing arguments tomorrow afternoon. I will do my very best with just one mid-morning break to get through all of these, the first part of the instructions. Then the state will give its closing argument. I'm giving the parties 1 hour each. I think that's reasonable under the circumstances. Whatever the state doesn't use in its initial time of closing arguments, it can reserve for rebuttal. But then following the state, we may need to take a break of some sorts, probably before the defendant goes, just for the jury's sake and the party's sake. We will need a comfort break. But you should be prepared to go tomorrow afternoon. Then the state, if they have any rebuttal, will get up within that time limit. I will myself, and I'll have my clerk make sure we accurately time that. I will read the final instructions, and I'll really leave it in the jury's hands. If they want to start deliberating, that's fine. You know, if it's 7 o'clock at night, I'll probably tell them we're going to break for the night. They'll be sequestered, but they will come back and begin deliberations in the morning. That will be Wednesday morning. But now that I really kind of laid that out and thought about the break I will have for closing arguments with even my 107 pages, we can get this done tomorrow.
All right.
And so that's my expectation.
Nice.
So, Mr. Brooks, I'll unmute you, but that is the expectation of the court, that closing arguments will be done tomorrow.
You can't rush me to judgment, or you can't practice law from the bench and tell me when I can do something and when I can't.
Mr. Brooks, I actually can, under all of the rules of procedure. It is my job to make sure there's effective and efficient administration of this trial.
Then I should be allowed to, then if that's the case, then I should be allowed to tell the jury what they need to know, which is the truth. That they have the power. They have the power to nullify laws if they don't agree.
You are absolutely not allowed to tell the jury that. There's a jury instruction that I will have ready to go if you even attempt to raise the issue of jury nullification, sir. You have absolutely no right to raise that. That is clear under the law.
I can raise what I want to raise. And you can't, so you added these jury instructions at the last minute, then you should have never approved them from the get-go, because I never approved them. I told you I didn't understand them at all whatsoever, and you still passed it.
Sir,
That's
if you understand
problem,
jury nullification, you understand jury instructions. It's clear to me you've done your homework.
What you talking about? I don't care what you're talking about. I'm going to let them know that they can nullify any law they don't agree with, which is my right.
It is not your right to do that.
Say that it's not.
It is not your right to raise jury nullification.
Show me lawful law then. Show me.
All right, I'm going to mute him once again. He's starting to raise his voice. He's starting to hit his hands on the table. It's very clear to this court that it's going to be a challenge tomorrow during his closing arguments. He does not have an unfettered right to say whatever he wants or how he wants. If he is going to be adamant about defying the court's rules, which I will tell him in part what they are today, and I will work on that as we break and have a very clear advisement for him tomorrow morning. He may run the risk of being put in the other courtroom because he'll forfeit by his conduct his right to be present here, and I will be able then to exercise the mute function. I have to balance, frankly, the fact that he's in custody, that it takes time for this jury to be excused. They have to walk an entire hallway behind me. I frankly don't want him to look worse than what he's looked, frankly, in front of this court when they haven't been in this courtroom. I need to preserve how he looks to this jury. And I will need a very clear pledge by him that he will follow the rulings that I make as it relates to the closing arguments. He cannot raise jury nullification. He cannot raise facts that are not part of the record. He cannot raise subject matter jurisdiction. He needs to argue the facts based upon his theory, based upon the evidence that's been presented, and those are the bounds.
And he's such an idiot. She has tried to do this for him from the beginning, but he won't accept it. Like, she actually does try to make sure that he doesn't look his absolute worst, like she's mentioned, which Darrell's gonna make sure that he looks terrible. Like, the way that he carries himself in this courtroom is absolutely horrible. And people mentioned it in the comment section. They were saying he truly believes that the jury will see him as like somebody that's fighting back against the system, and he's being oppressed in this moment. So they're gonna somehow say that he's not guilty for running through a parade. Okay. Nothing else needs to be said. Nothing else needs to be said there. It's like I said, his mind, the way it functions is just completely
if he's
off.
going to, I can only imagine there may be some objections by the state. If there is an objection, I expect that he will stop and wait for this court to rule on the objection. I expect that if I sustain an objection, that he will honor it. And if he can't pledge to follow these very simple rules of courtesy and decorum that are consistent with the rules of procedure and the rules of evidence, then he will be in that other courtroom for his closing argument, so that I can exercise mute, frankly, to protect how he looks to that jury. Because that is the balancing that I am tasked with tomorrow, is to ensure that this jury makes a determination based upon the evidence and the law. You do not have a right to talk about sympathy. That's very clear in the case law, whether it's evidence or arguments. The juries, if you read through the jury instructions, sir, you will see they are specifically told they will not be swayed by sympathy, by prejudice, or passion. They are not to be concerned themselves with any penalties. You can't argue penalties. You can't argue jury nullification. You can't argue legal issues that aren't relevant to the elements and the other law that's in these jury instructions. And those are the very clear rules that you will need to follow. And like any other time in this trial, if you don't do that, you will forfeit your right to argue your case to the jury, or forfeit your right to be present in this courtroom and appear from the other courtroom. And you are squarely put on notice of that here today, sir. With that, I think I've addressed all of the issues the state has asked me to address. Oh, one other issue, verdict timing. I know we have some time on this. I realize that there are many, many victims who may still be watching the proceedings remotely. There may be news media, in fact, that may want to cover the verdicts, and that this jury will take some time due to the sheer volume of counts in this case. When this court is advised that verdicts have been reached, I'm contemplating between 30 and 60 minutes before bringing everyone back into the courtroom for the verdicts to be read in open court. And if parties believe I need to wait longer, then let me know. But I think some of it will depend on is it late at night? Is it during the day? Are we dealing with any kind of traffic issues? I realize Mr. Brooks has family in Milwaukee area that may want to be here as well. Even if I consider kind of, the outlying areas of Waukesha, you could be as much as 30 minutes away. So that's my initial thought on that. Any statement from the state on that?
Not on that issue directly, sir. I'm sorry, Your Honor.
It's okay.
I apologize.
Any other issues?
Yes, my other issue as to verdicts was seating, if you intended to maintain the designated benches for the reasons you just said.
I would intend to keep the seating as is.
Okay, with the
The
reserve.
entire side behind the state for victims.
Okay, and the other side
Public.
reserved for the first 5 minutes, or is that open seating over there? Or do you
My
wanna think
previous or my rule throughout has been 15 minutes. What I would say is any open seating will open the courtroom. It'll still be open the whole time because we're waiting, right? So it has to be. So any seat that's left open within 15 minutes, victims could also sit on the other side.
Okay, so does Darrell have anyone that's actually going to show up? Because I've seen a bunch in the comment section that people have told me his mom's not going to show up. I feel like I do remember somebody mentioning someone like speaking on his behalf or saying that he was actually a decent person to them, which I just cannot fathom like how that ever took place. I'm sure it was by mistake if he was decent to somebody, but yeah, I think I do remember maybe somebody shows up on that day and they actually say something for him.
Yes.
All right. Mr. Brooks, any further topics by you?
Am I muted?
No, you're unmuted.
So, again, I don't understand nothing you just said, but I don't. How can you deprive me of my constitutional rights? How can you trample on my constitutional rights? How?
Sir, you can forfeit
It's the perfect
a
time to
number of
mute.
constitutional rights by misconduct on your part.
Not if I reserve my rights. You can't let me reserve my rights and then take them from me.
Sir, I direct your attention to Chambers versus Mississippi,
I'm not
Rock
gonna
versus
hear none of
Arkansas,
that
State
because-
versus Anthony, Illinois
Did they
versus
reserve their
Allen,
rights? Did they reserve their rights?
the
Did
Beneby
any of those
decision.
cases-
There's a host
Did
of
they-
case
did they-
law, sir.
Did they reserve their rights?
All right, sir, you are simply mistaken on that. So I'm muting him once again. He's not giving me any other issues to address. We
Nice.
are in recess.
Oh, I'm sorry, I have a few
Go
other.
ahead.
I'm
You
sorry.
do. I'm
Yes.
sorry. Go ahead.
I just wanted the record to reflect that at about 2:04 p.m., your clerk had provided the final version of jury instructions to both the state and to the defense. I watched on video as Deputy Wittig left this courtroom, went over to the other courtroom, handed the final jury instructions to Mr. Brooks, and he immediately turned and dropped them to his left off the side of the table. I can't tell from the video if that's where the trash can is located or not, but I did see that immediate response after he was handed the final jury instructions. Another
Did that
thing.
include the verdicts or just the jury
No, just
instructions?
the jury instructions, I'm still doing verdicts.
Okay, it's just the jury instructions. But thank you, because I didn't see that given some of the things I was looking at up here, so I appreciate that.
Were all jurors or will all jurors then be told to report with an overnight bag?
That's part of the instructions that
Okay,
they were
and you're going to
given.
make that available to us?
Yes,
Okay.
I'll get Lauren down here right away, and I'll make sure that before Mr. Brooks is taken back to the cell, I see your arms waving, I'll get you in a second, that he's provided with that as well.
All right.
And you as well.
And then one final thing as to timing, and again, I
I
don't
know
mean
this
to be
response.
disrespectful to Mr. Brooks or
It's going to be
anyone involved
insane.
in this matter, but should there be any guilty verdicts in this case, would you be intending to proceed to sentencing yet this week or at a future time?
You know, that's an interesting question because I don't know how many victims will want to speak. If we have time, I would certainly consider that. I mean, I have this entire week set aside yet. And I have Monday morning, but I have some other things Monday afternoon, and then I am not available the rest of next week. So it really just depends on the timing. I would need to know from both the parties whether they anticipate anyone speaking other than the parties themselves. Any family members?
Yes,
I don't
we-
think I need a PSI. This is a trial. This is not like a guilty plea. So, Mr. Brooks, I'll get you. I'm unmuting you. Go ahead. Go ahead. You're unmuted.
It's just going to be an attack from start to finish. Here we go.
Since we're all making records to make me look bad, I think we should say for the record that one of the rights I have is to demand that the court places in evidence any unrevealed contract, statute, laws, rules, or information being used against me under the Sixth Amendment. So how come that hasn't been placed in the evidence?
What law are you referring to, sir?
I'm referring to my rights under the Sixth Amendment.
And what
My
case law
constitutional
says you
right
have a
under the-
right to do exactly what you just said you have a right to do?
The Constitution, Amendment 6.
Sir, that is very general, your statement. It's vague. There's nothing
So we gonna
specific
go what?
you have
What
referenced.
You want You want paragraph 2 or something like that? Is that what you want?
No, that's not what I'm saying, sir. You're
Fisher
making
Price
general
attorney.
arguments that aren't based on.
You absolute Fisher Price attorney. I just, I mean, we only have like a couple minutes left. I wish that as soon as he spoke, she just says, all right, we're in recess. And just, we all
Fact.
move on.
And are overgeneralizations of what the law requires as well.
Oh, straight to the trash.
I accept for value, return for value, any documents in this matter. Since, you know, it might be another record of what I'm doing, you know, since it's always a record of what I'm doing. And I also have the right to ask, is this common law or admiralty law? Because judging by the gold eagle on top of the flag, it's some explaining that needs to be done. And that is a military symbol. So is this a common law court or admiralty law court?
Mr. Brooks, I'm frankly not going to address these nonsense legal theories of yours. I'm muting you. They have been debunked. They are typical sovereign tactics that have no place in our judicial system. We are in recess. I'll see everyone tomorrow morning at 8:30. I'll just direct the bailiffs to wait until we have the verdict forms to give.
He feels so happy with himself right there.
We'll make sure they're delivered to him in his jail today. Thank you, everyone.
Thank you.
What a clown. He felt so happy with himself right there. He's thinking, oh, she muted me because she feels I caught her on something. Yeah, sure. Okay. Okay, I'm pretty sure he just mouthed the worst lawful law or something. At this point, I'm just trying to see if he's going to do anything else. All right, so that is the panic of a man that understands. The cell doors are starting to close in on him. I mean, he's known this from the beginning. Okay, so I did see the moment where she handed him the sentence of like 700 years. There was a point where like I cut to it because he was being so annoying. Like I just had to look at that to know that there is going to be like some justice dealt out at the very end. I'm pretty sure even when he receives that sentence, he's not all the way surprised. I mean, I'm sure he's surprised at the fact that they didn't care about how he feels in this situation and all this nonsense, as Judge Darrell put it, which is what it is. Like, he wants us to care so bad about his rights and the way that he feels about the whole process, when he's the reason that we're all here right now watching this, and we're watching it to see him get put away. I don't even know how else to describe it other than just him being an absolute moron. Oh, and also I think at one point in one of my videos I said that like Darrell graduated high school. From what people are telling me, he actually didn't. So thank you for letting me know about that. I think you said he got kicked out because of his behavior, which is not a surprise at all. But I guess we're gonna go ahead and call this one here. If you enjoyed the video, please like, share, and subscribe. Hope you did something good for somebody today. Hope somebody did something good for you, and I will catch you all in the next one. Peace.